Hello everyone, welcome back to my channel. In this video I will cover the cruelty and desertion as grounds of divorce and judicial separation. Okay, so in my previous video I have covered the adultery as a ground of divorce and judicial separation. You can check out that video also. Okay, so today I'll cover the cruelty and desertion as grounds of divorce and judicial separation. So let's get started. Okay, so section 13 Clause 1, Subclause 1A of the Hindu Marriage Act is dealing with the cruelty as a ground of divorce and judicial separation. Here, this section is saying that on the ground of the cruelty also, the aggrieved person can seek relief. Okay, the aggrieved person on the ground of the cruelty can file a petition for divorce or judicial separation. Okay, section 13 clause 1 subclause 1a is saying that when after the solemnization of marriage respondent has treated the petitioner with cruelty, the petitioner can go to the court and file the petition on the ground of the respondent's cruelty and can seek relief from the court on this particular ground when the petitioner has been subjected to the cruelty. Okay, so on this particular ground, the aggrieved person, the petitioner, can file a petition on this particular ground. Okay, the next let's move on to the next ground, that is the desertion. Okay, section 13 clause 1 subclause 1b of the Hindu Marriage Act is dealing with the desertion as a ground of divorce and judicial separation. Okay, so here it is clearly mentioned that on the ground of the desertion also the aggrieved person can seek relief and can file a petition either for divorce or judicial separation. Okay, but here that petition will be maintainable only when the desertion on which the petition is filed, that desertion is continued for a period of 2 years only. Okay, if it is continued for a period of 2 years, then only the petition can be moved on the ground of the desertion. Okay, I will tell you that what is the desertion. Here it is said that desertion is when one of the parties to the marriage has left the other party without any reasonable excuse. Okay, there is no reasonable excuse to leave the spouse, but still one of the parties to the marriage has left the other without any reasonable excuse, and that too without the consent of the other party. That means the deserting party has not obtained the consent of the other party, of the deserted party, here to desert the other party. Okay, so if the consent has been obtained by the deserting party, okay, of the deserted party, then it will not be considered as a valid ground. Okay, so here desertion should be without the consent of the deserted party. Okay, also it should be against the wish of the other party. That means the desertion should be against the wish of the deserted party. Okay, and also it should be continued for a period of 2 years or more. Okay, then only the relief can be sought by the aggrieved person or by the aggrieved party on this particular ground. Okay, so if it is continued for a period of 2 years, then only petition can be moved. Okay, here if the desertion has not been continued for a period of 2 years, okay, then this petition which is filed on the ground of the desertion will not be maintainable. Okay, so here in order to seek relief on the ground of the desertion, this desertion should be continued for a period of 2 years. Okay, so that decision should be continued for a period of 2 years only, then only the petition can be presented before the court on the ground of the desertion for either for divorce or for the judicial separation. Okay, here it is also said that if the deserting party, who has left the other party, who has left the spouse, okay, that party, if that party has not returned to the other party, to the deserted party, before the expiry of 2 years, okay, during this period, okay, before the expiry of 2 years, if the deserting party has not returned to the deserted party, then it will considered as a valid ground. Okay, and the aggrieved person, the deserted spouse, can go to the court and file the petition on the ground of the desertion. But what if the deserting party has returned to the deserted party before the expiry of 2 years, within 2 years? Okay, so here it will not be considered as a valid ground for filing a petition, okay, for the divorce or judicial separation. Okay, so here it is clearly mentioned that if the aggrieved person is seeking relief on the ground of the desertion, that desertion should be continued for a period of 2 years minimum. Okay, if it is not continued for a period of 2 years, okay, then it will not be considered as a valid ground. Okay, also relief can be sought by the aggrieved party on this ground by presenting a petition either for divorce or judicial separation before the court if the decision is continued for a period of 2 years. Okay, but if the decision has been terminated before the expiry of 2 years, okay, so here the person cannot file a petition on this particular ground, on the ground of the decision. So there is one condition, and the condition is that decision should be continued for a period of 2 years, then only it will be considered as a valid ground, and the aggrieved person can seek relief on the ground of the desertion if it is continued for a period of 2 years. Okay, so I hope this topic is clear to you all. Okay, and yes, if it is clear to you, then don't forget to like my video and subscribe to my channel. In the next video I will cover rest of the grounds of judicial separation and divorce. Okay, thank you so much for watching this video.